Well, I want to thank Pam for the opportunity to be the educational provider for the chamber. I promised that I would speak loud, so thumbs up, thumbs down. But I'm also a soccer coach, and as a soccer coach, if you want that player on the other side of the field to hear you, you have to be pretty loud. So I'll do my best so that they can pick things up with the camera, and so that you guys can all hear me. And in the process of doing this and coordinating, the event, one of the things I always tell the promoter is to make sure you let them know this is a chance they're going to get their money's worth, because you're going to be able to ask an attorney anything you want to ask them and not get a bill at the end of the conversation. So hopefully you'll feel like you got your money's worth there. And I want to begin, before I dive into the estate planning. There's handouts that each of you should have at the table. That's going to be what I'm going to go over. You can take notes on it. If you have questions as I'm going through, you're welcome to raise your hand. I'd be happy to answer the question, or I will stay after as long as needed to make sure that everybody gets the chance to ask any of the questions that they have. But as I was, meeting and talking to people before things got started, Ryan said, McKenna, if you want to make it successful, you got to tell a joke or two. And I thought to myself, well, I'm an attorney. I know a lot of jokes about attorneys. So here's my joke for you to get this going. There were three professionals, and they were having lunch together. There was a doctor, there was an engineer, and there was an attorney. And as they're eating lunch, they start talking about whose profession is the oldest. And the doctor says, well, it's me, guys. My profession is the oldest. And they're like, well, really? What makes you so sure of it? And he says, well, let's open up the good book. And right at the beginning, it says, there was Adam, and then the Lord took a rib and made Eve. And if that's not a medical procedure, and so, the doctor was pretty, feeling pretty good, and the engineer was over there shaking his head. And the doctor turned to the engineer and said, now, come on, I proved my point. And the engineer said, well, in that same book, you can look, and it talks about how the Lord took and organized the matter and created an earth. That's before Adam and Eve, and that is an engineering work. And so the doctor had to, give up and say, you're right. Yeah, you beat me. Wow, you win. Lunch is on us. And the lawyer was over there shaking his head. And they said, oh, come on, And the lawyer said, well, in that same book, it said that there was chaos that the Lord took and made the earth. And who made the chaos? If not the lawyer. I am an estate planning attorney. For 22 years, that's what I've done. I've done wills, I've done trusts, I've administered estates when somebody's passed away. It has been my goal to eliminate chaos. When somebody dies, there is inherently, pardon the pun, inherently some chaos that can come along. That can be minor, that can be major, that can be anywhere in between. But there are things that have to be done when somebody dies. And a lot of those things that have to be done are law-related. And if you've done your planning beforehand with a particular attorney that's very versed in that chaos that comes there and how to get it so that it's less, you can help minimize that. That has been my goal, and I'm not going to say that I've completely accomplished it, and I bet you there's some clients out there that have said, you made my life a lot more complicated. When you kind of have to go through and get some of that stuff put together. But the reality is that any of the complications, at least in theory, those complications are to make it easier on the backside. So having said that, because you can do nothing, right? That's less complicated than doing something. But on the backside, you're going to leave a bigger mess. So today, the education is about what can we do? What planning can we get done to help make things easier on the backside? There's things that have to be done. What can we do? So you've got a handout, and it's got just a few bullet points that we're going to cover. And again, I want to make sure all of your questions are answered. In fact, I'm going to open it up right now because we're not that big of a group. We've got time. I know how to cover, and we can cover what we need to cover. I want to make sure your questions are answered. And a question that you might have is probably a question that at least a half a dozen other people might have. Is there a question question that somebody has that came specifically hoping that I will answer that particular question that they have? Thank you.
How do I pass my business on to my kids at some point?
Ooh, great question. Business succession planning. And we will talk about the basic elements and the basic tools that can be used to do that. And that's the legal side of it. You've got the whole business aspect of it as well. That's really important to recognize. The majority of businesses don't make it through that generational transfer because those that you're passing it to have not been properly trained, they've not been properly groomed, and I'll go out on a limb and say they've not been properly through the refiner's fire, because a lot of times what happens is the business owner has worked and worked and worked, had little, created something that was great, and it was too easy. They didn't go through the cocoon. You know the story of the caterpillar and the butterfly. You watch that caterpillar when it changes and it's coming out of that cocoon, or the little chicken in the egg. That struggle of getting out of the cocoon or getting out of the egg is what makes the chicken be able to survive, or the butterfly be able to survive. And that is my theory, and a lot of times, as to why it's not a successful transition, is because that younger generation has just not had to work as hard as the one that made it happen. That's a non-legal component. Today I will talk to you about tools from a legal standpoint on how you can make it easier, because there's also businesses that just lose it because you didn't do the planning. You didn't have any planning in place. The heirs inherit it by the intestate succession statute, and with no plan, that is a plan for failure, because it's going to be very difficult to have that business succeed if it's just going according to the state statute for where. I don't know if you knew this, but every one of you has an estate plan. Every one of you sitting in this room has an estate plan. Whether you've ever done a will or you've ever done a trust, we all have a plan. Because the state of Utah and all the other 49 states have what's called an intestate succession statute, where the state legislature says, this is what we think a citizen would want if they died. And it's not saying give it all to the state, because we know that's not what citizens would want. It's saying, give it to a spouse. But if they've had children from a prior marriage, then split it between the spouse and the children from the prior marriage. And it goes through basically what they think a citizen of the state of Utah would want. It's going to require a probate. It's going to be an intestate probate. But each of you have something. Now, if you want to trump that plan, that's what we'll talk about today. What tools can you use to trump that plan? Great question. Hopefully I address it. Anything that I don't address, come up afterwards and we'll talk a little bit more about it. Anybody else have one?
Why do you set up a family trust?
Does anybody want to try to throw out a layperson? I want to throw out an answer to that. Why a family trust? It's a great question. That's the most popular question in my office. Will versus a trust. Why are you saying trust? Does anybody want to throw out maybe what they think is the answer to that?
So you know what, so the assets are going forward.
That is the exact answer. That's a perfect answer. 100% right on that pop quiz.
I didn't hear what you said.
The answer is a trust can avoid probate. A will cannot. A will has to go through probate. What the will does is it guides the probate, but it has to go through the probate. If done properly, the trust can avoid the probate. That is a great springboard to get us right into the dialogue that we want to talk about, because that's going to be one of the biggest issues in what I can try to educate you about. So great question, great answer. Let's start. If you're going to talk about estate planning, you've got to talk about what do you own and how do you own it, because that affects the planning. The first thing I want to ask you, this is a group of educated citizens in Washington County in the state of Utah. Do you live here in Utah in a community property state or a separate property state? Everybody is going to have to vote. How many think separate property? Raise your hand. How many think community property? Raise your hand. It's usually the case. How many didn't vote? No. It was about a 50-50. It was actually a few more on the community property. You should have been teeing off here on Radmel, the CPA. It is a separate property state surrounded by community property. Nevada community property, Arizona community property, Idaho community property. California is not our neighbor, but we get a lot of California influence. All of those are community property states, and there's more. But Utah's not. Utah's a separate property state. That makes a big difference. Not only because it affects actually what you might own or not own if you're a husband or wife. That's not actually as important in a separate property as it. But there's a big reason on the tax side. What it relates to is what's called a step up in tax basis. Now that's a weird term, Radical and maybe a couple others but it's an unusual term that you hear about. Has anybody in this room had to pay a capital gains tax? Raise your hand if you've had to pay a capital gains tax. If you have a business and you go to sell that business, you'll be well educated by your CPA with respect to a capital gain, generally, if you've got a successful business. But if you've had to pay a capital gains tax, the stepped-up basis is your best friend. The way a stepped-up basis works is if I bought something for $10,000, I bought some real estate or I bought some stock for $10,000, and it's appreciated to $110,000. I have $100,000 of gain. That's what the government wants to tax in the form of a capital gains tax. If I sell it, Uncle Sam wants a portion of my gain. If I hold it until I die, my family, my heirs, get that asset, and if it was worth $110,000 when I die, that becomes the new tax basis. And now they only have to pay a gain on any appreciation above the fair market value when I die. Hence the term stepped up tax basis. You have to get it when you die. That's a heck of a way to, avoid taxes. But it becomes relevant if you're in a scenario where you know somebody that may be a parent or yourself, you're older. You're thinking to yourself, I liquidate that now, I'm paying Uncle Sam capital gains tax. I hold that asset, I pass away, it's gone. It gets more interesting in the context of community property and separate property. My wife and I in Utah own the asset, paid $10,000, took title together, it's now worth $110,000, and one of us dies. The rule is half the capital gain tax goes away. Two owners, one died, half the gain gets stepped up. But if it's community property, because of the provisions in the tax code, the entire community gets the stepped up basis. So if I died and it was community property, my wife can sell that asset and pay zero capital gains tax. That's a double stepped up tax basis that relates to only community property. Well, why am I talking to you about that if we're in Utah and we're a separate property state? Because there's a lot of people that have relocated from a community property state. They retired from one of those 10 community property states. Now they're in Utah. They can preserve the community property aspect of their estate if properly done in their estate plan. And they need to make sure they document that and they preserve that. And then if something happens to one member of the marriage, the other can sell with no tax. So it's an important provision to make sure that you're aware of, either for yourself or somebody you know that's relocated from a community property state. If they were husband and wife there, they want to make sure they take advantage of the transfer of that community property status into Utah, which they can if properly documented. Questions on that? Let's go on to another concept of ownership. So that was the separate property, community property. Kind of wanted to cover that a little bit. That first part too, I like to talk about something called joint tenancy. A lot of us have heard of joint tenancy. Joint tenancy with the right of survivorship. Many husband and wives, that's how they'll originally take title. Husband, wife, joint tenants with right of survivorship. Utah's made it now so it's even a presumption that it'll be a joint tenancy with right of survivorship because it's a very functional way. Presumption if it's a husband and wife. It's a very functional way to take title. One member of the marriage, the husband dies or the wife passes, what happens to the property? Somebody used that term automatically. That's a great term. It automatically will pass to the surviving spouse. No probate, Will that work?
Dangerous.
Oh, that was a good answer. That was the right answer. It will work, but there is a lot of risk. And when the client understands the risk, it's very rare that they're going to do it. First of all, they made a taxable gift. Normally, if it's a house or it's a piece of real estate that's in excess of the annual gift tax exclusion, $14,000 per year, and so they're going to have a gift right there. You've got the problem with respect to that they're going to lose their capital gains tax exclusion that you get with the house. If you're not aware that that whole capital gains tax that I was talking about is excluded in the context of a personal residence if you live in it, but when you put children's names on it, they don't live in it. And so all of a sudden you lose a $250,000 gain exclusion by having their names on it. But worse than all of those other things is you create potential liability. All of a sudden, if your son or your daughter goes through a divorce or has to file a bankruptcy, your 1/5 of the home is part of their divorce or their bankruptcy or their lawsuit. So it's risky. It's dangerous, and it doesn't make sense because there's better ways to avoid probate, and that's what we'll talk about next. Any questions? Anybody have a yes?
Wouldn't that affect the property tax, whether it's a first home or second home?
It may as well. It may as well if it triggers the county authorities. That's a point as well. Any other points? Let's look at that probate because we're hearing that term. It's come up now a couple different times. I mean, how many have heard of the term probate? Raise your hand. I mean, everybody, right? How many can explain what probate is? Raise your hand. That's good to see, brother. But simply put, probate is the process of getting the deceased person's assets to the living people or the beneficiaries. Probate is the process of getting somebody appointed that can do that. So what do I mean by that? Let's go through this. Jeff McKenna, I own property. I own a bank account. I own a piece of real estate. It's in Jeff McKenna's name. If Jeff McKenna dies, nobody can do anything with that bank account or that real estate because it was in Jeff McKenna's name and I'm not with you anymore. I'm gone. So a living person has to go to the court to get authority to handle the affairs of the dead person. That's the probate process. That's how it works. If you understand that, you'll understand the concept of a trust so much better, which we're going to talk about in a minute, and I'll remind you. And you'll be able to use your trust so much better. A will, we already said, doesn't avoid the probate. If Jeff McKenna does a will, that will is meaningless. It's nothing more than words on paper. It doesn't have any effect until a judge validates it as the valid last will and testament of Jeff McKenna. Then it governs, and the person that submitted the will has to go and follow the will per the terms of the will. But the judge has to give everybody an opportunity to state a reason why they don't believe the will is valid or why they have problems with it, and that's part of the probate process of going through that procedure. A trust does what the will does, meaning it governs where the property is to go, but it does it without the judge. It does it without the court. Nobody needs to be appointed by the court and have authority to handle the affairs of the dead person because the person, me, in this case Jeff McKenna, while he's alive, created the Jeff McKenna Trust. And he took the assets that he owned, whether it was a business, whether it was a piece of real estate, whether it was a bank account, and he coordinated those assets with his trust. Jeff McKenna will die, but my trust doesn't. That's why it's often called a living trust. So if you create the trust, and then the assets are coordinated with the trust, when you pass away, it's all self-contained within the trust. And the successor trustee, my oldest daughter, whoever I designate, steps up and then can administer the trust per those terms, never needs a judge, and never has to go through probate. But there's a really big key, and this is the part that you'll understand when you understand the concept of probate. Jeff McKenna, while he's alive, has to move the assets out of Jeff McKenna's name. Or the assets can be in Jeff McKenna's name, but they have to have a pay on death as the beneficiary. So it just flows into the trust. So if it's in the trust, or if it's pay on debt to the trust, or pay on debt to other beneficiaries, there's no probate. And everything gets taken care of. But the key was, the assets have to be coordinated with the trust. If I had to say in my 22 years of being an estate planning attorney, what is the biggest problem in somebody's estate plan? It's that they have a trust plan and they've not funded it. They've not made sure that all of their assets are coordinated with the trust. They bought a new house, they relocated, they bought a new house, and they didn't remind the real estate agent or the title company, hey, I want this in the name of my trust. Or they open up a bank account and they just forget and they don't take it in the name of their trust. If you have a trust, but the assets aren't part of the trust, they're going through probate. The trust avoids the probate as long as the assets are coordinated in it. Any questions on any of that? Personal questions, anything? This is your chance.
So I work in America First Credit Union, and we have members come in, and they're told by their attorney that they need to come in and put the account into the name of the trust.
And they have a heart attack if you say you'll make it pay on debt.
So why do you think that's done that? Why do you think the attorneys say that? What's the benefit of putting the account into the name of the trust in compared to the POD?
I'll be honest with you. I specifically tell my clients, I remind them, my instruction sheet says, in the name of the trust, or, and I always circle it, pay on debt to the trust, and then I underline it. And I will say to them, a lot of times the institution is going to want to do this, pay on debt to the trust. And I will explain to them, what's better, 6 eggs or a half a dozen? I explain to them, it's the same. From my attorney's perspective, you can make a little bit of an argument that if it's in the trust, then they don't have to use their power of attorney if they become incapacitated. But, that's why we have the power of attorney. So I don't fight the system. I just say whatever is easier for the institution, because I know many institutions prefer that it stay in the individual's name, but they're happy to put a pay on debt designation. And it works, in my opinion, it works just as good.
That's what I thought, but I just wanted to get your opinion.
Yeah.
Do you have to list if you got a boat and you have cars and so on, do they have to be listed in your trust?
What's interesting is whenever a client asks that question, I know the client is processing what has to be done and is thinking about it. It's a great question. And it's nice to have a nice answer. In Utah, Arizona, and Nevada as well, the states that I practice in, you don't. The Utah code specifically exempts 4 vehicles. So you don't have, and I tell clients that's 4 vehicles per trip to the DMV after you die, because I've never seen them count, vehicles. They don't want to encourage and enforce a probate. They don't want to tie up the courts with the probate. So the DMV is very, very easy to work with. And I tell clients, don't worry at all about transferring the car into the trust, because it'll be just as much work when you die. It's a trip to the DMV with a death certificate as if you didn't transfer it into the trust. It's a trip to the DMV with a death certificate. So, in answer to your question, no, you do not have to retitle those. And our documents, what we do is a simple bill of sale. It's a generic bill of sale saying, any and all of my personal property, I hereby transfer into the name of my trust. So there's a paper trail to show that the trust will govern how it's distributed. If Johnny runs down with the death certificate and a certificate of the title, and he gets the title turned into his name, and then he says the car's mine, no, there was a bill of sale that said the car would be governed by the terms of the trust. You may have got to switch into your name, but we're going to give you less of other assets because you got the car, and now we're going to divide it up evenly with that being part of what you already received. Good question. Any other questions about?
Is there ever a reason or a circumstance where a couple or a person would establish more than one trust?
Yeah, that's a great question, and especially in the context if you're trying to do asset protection, if you're trying to do estate tax minimization, and we'll talk more about estate tax in the end, but this is as good as any time to talk about it. If you have an estate that exceeds $5,490,000, that number is so much higher than it was back when I started. When I started, it was $600,000, and that's a number that maybe some of you have heard, or $600,000 was the number. Anything above that, the federal government wanted a portion. Now that number is $5,490,000. If you have a husband and wife, you can double that with some planning and with some different, provisions that the government has now given us with respect to it. The estate tax is much less of a consideration than it used to be. It's still, if you're in that realm, a very big consideration because the Uncle Sam wants a big chunk. and you can do certain planning. But oftentimes, that would be when you would look at additional trusts, because you're trying to minimize your estate tax exposure. So what you might do, for example, an easy way to get rid of some estate tax exposure is to move life insurance out of your estate. So let's say if you had a $1 million life insurance policy, if I die, that's counted as part of my estate for estate tax purposes. So when you're calculating, do I have a taxable estate or I don't have a taxable estate, life insurance is part of that calculation. And some business owners can get fairly large policies that could affect that. Well, that is an asset that's not difficult to move out of your taxable estate by putting it in an irrevocable life insurance trust. So that's a special kind of trust that gets life insurance out of your taxable estate, but it would be separate and apart from your basic trust. You also, in the state of Utah, we have a domestic asset protection trust, and a very good statute with respect to that, although some legislatures have spent a lot of time trying to attack it, but it's a powerful asset protection provision. The only requirement is that you can't make yourself insolvent. You can't put everything, and it doesn't really define what insolvent is, which leaves it, whenever something's not defined, lawyers will fight about it. But as long as you're not, there's an adage that goes along in tax law, estate law. Pigs get fat. Hogs get slaughtered. When you're talking about asset protection, if you try to put everything in there so that you have everything protected, you're probably going to have to be defending why that created an insolvency that goes against the statute, and then you lose your protection. But if you're wise and you just put, half the assets, you kind of are, smart as to what assets you put in that domestic asset protection trust, it's got great provisions to prevent somebody from suing you to get at those assets. And so the concept is to make it similar to an offshore trust, but just be able to do it domestically within the state of Utah. And the Utah has had it for a number of years, but it wasn't good. It was about 5 years ago, they revised it, and it's now one of the better ones in the state, in the country.
And I assume you could assign a different trustee then to that.
You have to, actually. And see, that's one of the dilemmas on the domestic asset protection trust. You can't be your own trustee over everything. You cannot be in charge of the distribution out. Used to be you had to have a Utah institution that was doing that. That's why nobody really wanted to do them. They didn't want to pay a Utah institution. Now, it can just be a citizen of Utah. So you can be, what you can do is you can bifurcate the trustee role on a domestic asset protection trust. You personally can be the management trustee. So you're managing the investments, you're managing how things are done, and then you can have somebody else that's the distribution trustee. Then you can have a trust protector that says that distribution trustee isn't doing what they should do. I want my trust protector to step up, usually a CPA or an attorney that works for you, to fire that one and put a different one in. So you can still pretty much control it. You have to jump through some hoops, though, to get where you want to go. But those are some of the different kinds of trust. You have charitable remainder trust, charitable trusts that relate to giving to a charity where you can leverage what you're giving to your charity. So those are all some of the different options that are out there. But 95% of the trusts that exist in the United States and in Washington County are revocable living trusts. They have a lot of different names, but basically they are nothing more than a will substitute. They don't give you any asset protection. They don't protect your funds from Medicaid if you have to go into a nursing home. But they do what a will does without having to have probate associated with it. So, please.
What about bypass trust?
Oh, great question. Great question. Yeah, that is the second most popular trust. A bypass trust, where that comes into play is the minimization of the estate tax. And back in the day, when the threshold was $600,000, there were a lot of people that had what was called an AB trust. An AB trust is nothing more that said that, hey, there's a husband and a wife. And when one of them dies, don't give everything to the survivor because he or she then will have too much. And then when they die, they'll have to pay an estate tax. So the trust would say, bifurcate. Become an A trust and a B trust. Become a bypass trust, where it will bypass the surviving spouse. So basically you're saying, honey, when I die, it doesn't all come to you. Oh, wait a second. Well, it was just in theory. the surviving spouse could be their own trustee over it. The surviving spouse could use it for health, education, maintenance, and support. They could have access to it. They just didn't own it for estate tax purposes. And by doing that, you could double up the exemption amount, which is now $5,490,000. Back then it was $600,000. So there's bypass trusts that are out there. When one spouse died, they created that trust for the surviving spouse to use, but not to own. So those would be the bypass trusts that are out there. They're irrevocable, and they have to have certain terms in order to qualify so that the surviving spouse that's using the money doesn't own the money. And that's the key. If they don't own it, it's not included in their estate for estate tax purposes.
Do you recommend that they turn that back into just a traditional trust without the AB provisions? Or do you say keep it in case laws change?
Yeah, that's $1 million question. And usually, you know, I mean, the laws have already changed to some effect. There's something called portability that you can look up, where you don't have to have the AB provision the way that you used to have, but you're limited to a certain amount of time in which to use it. If you miss that time frame, then you can, you know. Normally, if I see it, it depends on the size of the estate. I mean, if it's a couple $1 million estate, I'll probably still tell them, you know, you can keep it. I'll explain pros and cons, but keeping it's not necessarily a bad thing, because in addition to being able to potentially minimize estate tax if the law were to ever change, you also get asset protection for the surviving spouse. Because half of the estate will go into the bypass trust, of which the surviving spouse doesn't own. So if the surviving spouse is in a terrible car accident or is still doing business and gets sued in a bad business transaction, the estate that's in the bypass trust, that's not assets of the surviving spouse. So there is some benefit beyond just the estate tax benefit. But there's also a downside. You have to file a separate tax return on the bypass trust. You have to do some accounting, so you got to kind of weigh all of that. Great question.
A lot of the folks I work with have property all over the country, and are there any considerations you would want to make if, say, you have a house in Utah and then one maybe in Florida or Boston or wherever?
Well, definitely. When you create your trust, one of the beauties of a trust is it can void multiple probates. If you have a scenario where you don't have a trust, you just have a will, or you don't have anything, and you own real estate in more than one state, your family is going to deal with more than one probate. You have to do multiple probates to clear title to where all that real estate is. So the idea of creating something, and it could be a trust, it might even be a limited liability company. That's another, you know, when you talk about other things that you can have with your trust, an LLC is a great way to own real estate as well. And an LLC doesn't die, and so if things are in the LLC, there's no probate. But going back to that, yes, you would want to make sure you pulled and transfer that Florida property in, that Colorado property in. Attorneys in Utah should know they're not licensed in Florida or Colorado, unless they are licensed, which most of us aren't. They need to get an attorney in there. We have a database. The paralegal that does the estate planning has a database of attorneys across the country, and you're usually looking at about $200, $250 to get that Florida deed put in, but we make sure that all of that gets tied in. So when they sign it, they will sign a Florida deed or a Colorado deed or a Michigan deed, wherever they may have the property. Good question.
My husband and I each have 401ks, and we also each have IRAs. Since those are tax-deferred accounts, who should we name as our beneficiary? Our revocable living trust, or each other, or I've always been confused on that.
That is a great question. A lot of wealth exists in these retirement accounts. And these retirement accounts, everything that I was talking about with homes and real estate and stock and bank accounts, that all comes tax-free. If you're underneath the estate tax threshold, you're not paying Uncle Sam anything, you know, when you inherit it. But IRAs and 401ks are a different animal. Because the owner of the 401k or the IRA would have had to pay tax while they were alive if they took those monies out. Those that inherit the IRA or the 401k have to pay tax when they take the money out from their inheritance. Now, the big question is, do I name my trust? Do I name my spouse? Do I name my children? Or do I name a charity? Multiple choice, 4. Okay, if you're happily married, and you want to stay happily married, name your spouse. Spouse is always the best too because they can defer the tax the best. And so, generally speaking, you almost always are going to name the spouse. There's hardly anybody I've ever met that had so much wealth that the beautiful wife that could be a potential widow didn't feel like she should have the retirement accounts while she's alive. I mean, it just makes sense. That's an easy one. So if you have a spouse, you go spouse. Where it's more difficult is the backup beneficiary. If you and your spouse are in an accident together, then where does it go? Should it go to my trust or our trust? Husband and wife formed a joint trust. Should it go directly to the children? Or again, let's throw in that possibility of a charity. Talking about it. Trust is convenient. You name the trust, and then you've got all your backups provided for. If there's a minor, it covers it. If one of your children dies and it goes to your grandkids and there's a minor, you spell out how it's taken care of. If you just name the children, and one of them dies, and let's say there was 3 children, that 1/3 of the deceased child, you don't know where it goes. It depends on what the contract says. It might go to the issue of the deceased child, it might go to the heirs of the deceased child, it might go to the other 2 beneficiaries, it might become part of your estate. It just depends on what the contract of the company says. So you kind of lose some of that control as to who your backup beneficiary is, so you go back to, well, then McKenna, the trust is a no-brainer. I just name my trust as my backup beneficiary, and I cover all my contingencies, because that's what the trust does, you know? That is a good part. The problem is the trust can't defer that income tax implication quite as well as individuals can. The trust has to do it based on the life expectancy of the oldest of the beneficiaries, and so if you have a really old beneficiary and a really young beneficiary, it can affect how well they can take it out as far as what rate they can take it out. What I'm talking about is when somebody inherits, if they're not a spouse, if an individual inherits an IRA, they have to begin taking out distributions from that IRA right away based on their life expectancy. And so if they're a 60-year-old, that's going to be a lot bigger chunks than if they're a 40-year-old. And so that's some of the pro and con that you can look at. But let's talk about a really neat a provision here. I keep mentioning that charity. If you have any charitable intentions, your IRA and 401k, that is where you're going to use the monies to fund your charitable intentions. Because the charity will get every dollar. There's no taxes for what you leave to the charity. So if you've got money in an IRA or a 401k and you leave that to your kids, they're going to get a haircut. They're going to get a federal and a state haircut on the taxes they have to pay. If you leave it to a charity, charity gets every dollar. Let's make it even more exciting. You can leave it to what's called a donor-advised fund. Write that down if you have any charitable inclinations, or you deal with people that have charitable inclinations. A donor-advised fund is a poor man's private foundation. The largest charity in the world right now is Fidelity Funds. Fidelity Funds and Schwab, I think, is third. They have created donor-advised fund mechanism where you can contribute your monies into their charity. They do all of the work, all of the paperwork that would be involved if you created your own private charity like Bill Gates has created or any of these ultra-wealthy individuals. They do all that paperwork. And what you get is a little small account called your donor-advised fund underneath their umbrella of this big charity. And your little account is there where you name who you want to be in charge. I've done it, I'll tell you, a really fun plan that I did, we're almost out of time, but a really fun plan, is I took somebody's IRA and I carved it up. He had 5 children, we carved it up 10 ways. He had 10 beneficiaries. 1/10 went to the child, 1/10 went to the child's donor advised fund. 1/10 went to another child, 1/10 went to that other child's donor advised fund. Because that donor advised fund is their own private charity. And they can use that money on any charitable purpose. If you have a client that is a tithe payer, whatever denomination they may be part of, but they actively engage in paying 10% of their income, leaving that in a little private charity for them and allowing them to use that money annually to take care of their, or monthly or quarterly. They can make those payments. You can see the power. You left it to them in such a way that they get the benefit of every dollar. Uncle Sam didn't get anything. And they're already giving very generously to a charity. And so this just becomes the mechanism in which they can do it. Doesn't have to be just tithe, I mean, it could be anything. I mean, you get hit up, Snow Canyon's putting in a new turf field. If you live by Snow Canyon, beware. They're gonna come and be, hitting you up. And, out of my donor advice fund, I can just pull that money out and pay for any charitable bequest. So those donor advice funds are really fun, and they're really neat to use in connection with an IRA or a 401k, because the kids are gonna end up giving 30% or more, depending on their income tax bracket, to the government, state and federal. And you avoid all of that with the donor advice fund. Let me go ahead, last thing, just real quick, and then I'll be here for questions. Ancillary documents at the last of the list of items. When you do an estate plan, you need to make sure it's a complete plan. Will, trust, and then your ancillary documents. You need a financial power of attorney and a healthcare power of attorney. I tell my clients all the time, that is a worthless document. It's not worth the paper it's written on. When you die, but while you're alive, a power of attorney is what enables somebody to handle your affairs without having to go to court and become your guardian and your conservator. That's a $3,500 trip to the court that you avoid by having that little paper that says, hey, if I ever become incapacitated, I want oldest daughter to be the one that can make my healthcare decisions. I want, second daughter to be able to make my financial decisions. I'm incapacitated, they don't have to go to court, they can use those powers of attorney. When I die, they terminate. Criminal misdemeanor to use one. That's when the will and the trust have to kick in. But while you're alive, they're very important. So you need to make sure you have those. A living will, just telling the doctor, I don't want to be kept alive by machines. That's an important component as well in connection with your healthcare power of attorney. Just some of the important ancillary documents that you have as part of your plan. I want to thank you. You guys have been great. Questions have been wonderful. And I will stay as long as needed. I didn't block anything, so I can make sure you get your money's worth. And you can ask all the questions you want. You won't get billed. Thank you.